This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. This blog post number 4672 is about personal injury and why the personal injury coverage exclusion eliminates coverage for an insured who manages to violate someone else's trademark, and why speculation about extraneous facts does not trigger a duty to defend. AutoDistributors, Inc. and Steven Schneider, collectively AutoDistributors, appealed the district court's order granting judgment on the pleadings in favor of Scottsdale Insurance Company, Nationwide E&S Specialty, Scottsdale Indemnity Company, and National Casualty Company in a case called AutoDistributors, Inc. et al. Versus Nationwide E&S Specialty et al., a decision of the United States Court of Appeal for the Ninth Circuit on November 17, 2023, where the Ninth Circuit interpreted the personal injury coverage part of a liability insurance policy. This case arose from an underlying dispute between Sixt Franchise USA, LLC, and other Sixt entities who had entered into a franchise agreement that allowed auto distributors to operate a Sixt rental car franchise and use Sixt trademarks in connection with that franchise. Sixt sued auto distributors, claiming it violated the franchise agreement by operating a used car sales business at the franchise location and using the trademarks in connection with the business. Auto distributors tendered the suit to its insured, Scottsdale Insurance Company, and Scottsdale refused to defend or indemnify. Auto distributors sued the defendants, Scottsdale and other insurers, for breach of contract and breach of the implied covenant of good faith and fair dealing. The district court ruled for the defendants, holding that Scottsdale had no duty to defend auto distributors. In California and most states of the Union, an insurer must defend a suit which potentially seeks damages within the coverage of the policy. To determine whether there is a duty to defend, the insurer compares the terms of the policy with the allegations of the complaint and any other facts that are reasonably inferable or otherwise known. If the allegations suggest a possibility of coverage, the duty to defend is triggered, even if the precise causes of action pled by the third-party complaint fall outside policy coverage. Auto Distributors' insurance policy covers personal and advertising injury, defined to mean arising out of a specific list of offenses. The policy also, however, excludes personal and advertising injury arising out of the infringement of copyright, patent, trademark, trade secret, or other intellectual property rights, known as the IP exclusion, which is different from that in the general policies that cover personal injury. Some of Sixt's allegations clearly fell outside the policy's coverage. Sixt alleged that auto distributors breached the franchise agreement by operating the unauthorized used car sales business at their store and using the store to facilitate a startup incubator business. That alleged conduct did not implicate any of the offenses in the definition of personal and advertising injury, so it did not trigger the duty to defend. Sixt also alleged that auto distributors infringed Sixt's trademarks by using the trademarks in connection with a used car business. Based on these allegations, Sixt alleged claims of trademark infringement and false designation of origin under the Lanham Act, common law trademark infringement, and common law unfair competition. This theory was also part of Sixt's breach of contract claim because Sixt argued that the franchise agreement restricted the use of the trademarks. Even assuming infringement would constitute a, quote, personal and advertising injury, there could be no coverage for these claims because the policy's IP exclusion specifically excluded the cause of injury. That exclusion provides that the policy does not cover, quote, personal and advertising injury, close quote, arising out of the infringement of, quote, trademark, close quote. Although the Sixt complaint used the word slogan once, that single word did not trigger the duty to defend when read in context. AutoDistributors pointed out no allegation in Sixt complaint describing AutoDistributors' use of items associated with Sixt slogans as opposed to Sixt trademarks. An insured may not, therefore, trigger the duty to defend by speculating about extraneous facts regarding potential liability or ways in which the third-party claimant might amend its complaint at some future date. The extrinsic facts which may create a duty to defend must be known by the insurer at the inception of the third-party lawsuit. In my opinion, personal injury liability coverage is a very broad coverage providing defense and indemnity for multiple types of offenses like defamation and infringement of copyrights. The Scottsdale policy in this case provided a personal injury coverage, but limited it with an IP exclusion that defeated the claim of AutoDistributors because that exclusion was clear and unambiguous. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can also subscribe to the blog and you will be advised of blog postings, usually 5, sometimes 6 a week. You'll also have access to the more than 4,700 blog postings. And you can also subscribe for free to the videos on YouTube and rumble.com. And if you do, I'd appreciate it if you click on the link, the like button on YouTube and the thumbs up button on rumble.com. And if you enjoyed the videos and or the blog posting, please tell your friends and colleagues so that they too can subscribe. And if you're interested in learning more about insurance, insurance law, insurance fraud, and insurance claims, please consider for a very small fee of only $5 a month or $50 a year, subscribing to my Substack publication or my locals community. Thank you for your attention.